Chapter 28, Part 1. Here we're talking about investor protection and corporate governance. We're talking about investors in corporations. Usually we're talking here about shareholders or stockholders. Okay, so a little background here. Prior to the stock market crash in 1929, which led to the Great Depression, there was very little regulation of the sale of stock, or what we sometimes refer to as securities. As a result of the crash, the government, Congress, decided that there needed to be certain protections for the public so that it wouldn't happen again. And so the first law that was passed was the Securities Act of 1933. It is known as a Disclosure Act, meaning that there really wasn't much punitive aspects placed in it. It was basically if you sell stock, you have to disclose to the purchasers certain things so that they can make an educated decision whether to buy that stock or not. The idea being that because they didn't have that before this law, people were buying things with faulty knowledge, sometimes fraudulently given out, and that led to the stock market crash. So it was designed to prohibit various forms of fraud and to stabilize securities industry by requiring disclosure of certain information to investors. The Act also provides that all security transactions must be registered with the SEC unless they are specifically exempt from the registration requirements. We're not going to get into a whole lot about the registration process. It's way too involved for a course like this. However, I would mention to you that all this is done electronically, and the acronym for the federal government website that all this is recorded at is called EDGAR, E-D-G-A-R. You can go to that and you can find all the filings. And oftentimes those filings are very useful for many purposes. For example, when you file to issue new stock, you have to state whether you have any potential liabilities. So if you know that you're being sued for something, you have to list that, and that might be helpful to people who are thinking about bringing a lawsuit against that business. Okay, so it defines what a security is under Section 2.1 of the Securities Act. I'm not going to go through all these things that are listed on this slide. You can read them for yourself. Okay. The Supreme Court has defined a security under the Howey test that interpreted the statute and held that an investment contract is any transaction in which a person, 1, invests, 2, in a common enterprise, 3, for reasonably expecting profits, and 4, derived primarily or substantially from others' managerial or entrepreneurial efforts. Okay, there are many different types of securities. We talked about stocks as one of them. Bonds are also another type. Investment contracts can include condominiums, franchises, limited partnerships in real estate, oil, gas, and other mineral rights have qualified as a type of investment contract and therefore a type of security. Okay, so the key thing under the 1933 Act was registering your stock or your security if you plan on intending to sell it to the public. Okay, so unless it qualifies for an exception, you have to register it before it is offered to the public. And the registration statement must provide all the potential investors with a prospectus. The prospectus includes a lot of different information, but primarily it's accounting types of information about the standing of the corporation and what it is planning to do. It has to be written in English and fully describe these things. As I said before, any pending lawsuits or special risk factors is an interesting thing that has to be put in the registration statement. And again, this is listed on EDGAR, so you can go and look at that. And here's EDGAR, which stands for Electronic Data Gathering, Analysis, and Retrieval Database. So you can read through all these things that have to be in the statement that are on this slide. There are some things that are exempt. Small offerings, Regulation D covers that. Small dollar amount, or are in a limited manner, and you can look at the exceptions for those. Resale and safe harbor rules. The Securities Act provides for exemptions for resales by most persons other than issuers or underwriters. So obviously a sale from one person to another is not going to trigger a requirement under the Securities Act of 1933. Resales of restricted securities acquired under Rule 505 or 506 trigger the registration requirements unless the party selling them complies with special rules. These are known as the safe harbors. Okay, so if you violate the 1933 Act, intentional or negligent, and it defrauds investors by misrepresenting or omitting material information, then you're in violation of the statute. Or if you sell securities before the effective date of the registration, you're in violation. The remedies are fines up to $10,000, imprisonment up to 5 years. The SEC, which is the Securities and Exchange Commission, which oversees this, is authorized to issue civil sanctions such as an injunction against the party violating the law. Any private parties who purchase the securities and suffer harm may bring a suit in federal court to recover their losses and damages. Okay. Defenses to a potential violation. You can avoid liability by showing that the statement or omission was not material, that the plaintiff, the person who bought the securities, knew about the misrepresentation when the stock was purchased, or that the defendant exercised due diligence in preparing and reviewing the registration and reasonably believed at the time that the statements were true. This is not available to the issuer, but is available to the underwriter or subsequent seller. An underwriter is a person who takes a contract to sell the stock on behalf of the corporation. So that completes Part 1 of Chapter 28. We'll pick up with Part 2 next.